Kapil Sankla respond to this?
304 Part 2 is not attracted in this case.
That the investigation is unfair. The police was slothful in its own initial action, and therefore as a countermeasure to make up for their initial inaction, they're now leveling more harsh provisions, including culpable homicide, which may not be made out because not just is a charge against the driver but against the other occupants. And how will you ever prove in a court of law that they knew that this girl is stuck under the chassis and yet they continue to drive on?
Well, very importantly, the entire case is based on three terms which are very important. One is, of course, intention, the second is knowledge, and the third is negligence. This is not a case of negligence. It is nobody's case that this was a case of negligence. The question now only is whether there was knowledge or whether there was an intention. As far as Section 304 is concerned, punishment for culpable homicide not amounting to murder, it has two parts. The first part has life and up to 10 years, where you have the intention of causing death, and what is important is, or of causing such bodily injury as is likely to cause death. So I would actually argue that 304 Part 1, there was an intention of causing such bodily injury as is likely to cause death. And of course, the second part is knowledge that it is likely to cause death. But why I'm saying the first part here is applicable is because of this, that there are three eyewitnesses. One is, of course, the girl whose stand has been contradictory. But she's actually talking about contributory negligence, which is an argument in 304A and not really an argument in 304. So as far as Section 304 is concerned, her conduct is not important. The conduct of the accused is important. And as far as whether there was, the FIR was against one person or five people who were sitting in the car, also is of no help to the accused, for the reason that under Section 34, where there is common intention, the intention will be read into it, considering that they knew that an accident has been caused, that they were hearing the sound of the lady underneath the car and nobody stopped, and they were going round and round trying to dispose of the body which was stuck under the car. And how I'm saying this is, again, because one, the girl herself, who was the eyewitness, says that she was crying, the deceased was shouting, those people heard, they sped away. That is one. Second,
no, but the point is we don't know if that other girl Nidhi was actually there or not, because there is a CCTV footage which the likes of Diljit Ahluwalia will cite in court to say that 1 hour before this incident, this girl Nidhi is back home. Here's the CCTV evidence to say it. Now she's claiming later at the behest of the police that she was actually at the Mauke Wardat, the crime scene. She wasn't there, sir. The CCTV footage says she was back home in her bed.
There are two other witnesses, sir. One is a local confectioner called Deepak Dhaya, and another person who also was a delivery boy who was there. And their statement is also on record that they say they saw the body. They also saw the accused driving round and round, and they could see the body sticking out. So as far as the conduct of the accused is concerned, not only Section 34, it takes care of all the other occupants of the car, but in this case, when they knew that the body is stuck underneath and they were trying to dispose it off, they had full knowledge, please understand, and the intention of causing such bodily injury as is likely to cause death. In this case, clearly the imprisonment is for life or for 10 years minimum. That is one. The second, of course, are the allegations that have been made, but they are contradictory to the report that has been filed, the medical report, as far as any other untoward incident that might have taken place. If it is proved that this was a case of rape or any such instance, then we do know that IPC, there was an amendment in 2013 which pertains to death being caused as a culmination of such an act, where of course this is
Yashovardhan Azad, respond to the point
for
that Diljit Ahluwalia makes about the police now trying to show that they're acting, trying to make up for their initial slothfulness by imposing sections which may be difficult to prove in a court of law, which can be torn apart by a defense argument because you've gone overboard in alleging things which may not be proven inside a proper courtroom.
No, I think culpable homicide not amounting to murder is the correct application in this particular case. There are two things, as somebody pointed out in the beginning, that first the conduct of the accused, that they were trying to take frequent U-turns. That the intention of an accused a natural intention would be to just run away from the spot. But they were trying to take frequent U-turns, which meant that they were trying to get rid of that body. Even and here the views of the auto experts will come in, and I hope the court calls in the auto experts who can say that even as a driver, I know when I drive a car that anything attached to my mudguard, even very simple, or something attached to the wheel, I get immediately intimation. I feel that my car is dragging. But with a body being dragged like this from the front wheel and the axle, do you think it is possible or not? It's possible? I don't think so. I think so this part is really established. And I would again reiterate my point that despite the conduct of Nidhi, the substantive part of the evidence is established that the girl was being dragged the car, and these 5 gentlemen were going on and trying to release the body somehow from the car, detach it so that they could run.